The next case is State v. Manning. Again, each party will have 15 minutes to present argument. Counsel, would you like to reserve time for rebuttal?
Thank you, Your Honor. May it please the court, I would like to reserve 5 minutes for rebuttal.
Okay, again, we'll be keeping track of time up here and you can walk over there. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, or victims during your argument. You refer to them as initials or term like the child or the victim. The judge is ready to brief, ready to proceed whenever you are.
Thank you, Your Honor. May it please the court, my name is Attorney Wesley Buchanan. I have the privilege of representing Mark Manning, the appellant in this matter. The key for Mark's argument is manifest injustice. And, respectfully, this doesn't qualify that what does. So Mark pled no contest to a domestic violence in 1991. And so he pled no contest, and before we get to the true meat there, Mark Precipe, the court reporter notified this court that there are no audio records and there's no transcripts. In addition, the court denied Mark's motion to withdraw his plea without a hearing. So there were no transcripts for his hearing. So
are you required to have a hearing post-sentence? I don't believe the rule requires that.
The rule does not require it absent a good showing. And I believe that Mark made a good showing in this instance because he did attach in the motion to withdraw his plea. There were 2 affidavits for the child that him and his wife have in common and the alleged victim of this matter. And they both, that was included in the affidavit to withdraw the plea. Mark's position is that he entered a plea of no contest, was convicted of domestic violence, and then later the government passes a law and says you are now under a weapons disability. And that was never informed to Mark.
Well,
So,
before you get to that, failure to inform a defendant about a firearm consequence isn't grounds to vacate a plea.
correct, and that's in the statute. So in essence, the government says, I don't have to tell you about it, I'm going to pass a law and affect your rights, but then you can't bring that up into court.
But even now, if you're a defendant, there's no requirement to tell you about that.
There is no requirement in current criminal rule 11 right now. However, I've seen other trial courts as a best practices refer to people when they do a plea colloquy, this will place you under a weapons disability. Now, that's not required in the rule, and the case law does not say currently that that's required. However, I have seen that, and I can represent that to the court.
So you're arguing public policy.
The public policy is that, yes, the government can't make their own rules, and that's what courts are for. I mean, Mark has a grievance, he wants to address it, right? He took responsibility for an act. The government then puts a burden on him, right? Ex post facto, that's the definition. And then even worse, the government says, you can't complain about it. I mean, it's terrible. I mean, that's exactly what happened here. I mean, that's in the statute as this court just quoted, right? I can't use this to complain of something that you did to me after the fact, right? So Ohio's Constitution is a ceiling, the federal Constitution is a floor. Again, this is not a substantial right for Mark. This is a constitutional right. The Ohio Constitution, the federal Constitution, permit him to have a firearm. And
there's limitations to the Second Amendment. One of those limitations are law-abiding citizens.
currently,
Right.
I'm sorry, go ahead.
So one of the limitations are, we know that there's limitation if you're not a law-abiding citizen to own a firearm, have a firearm.
My understanding of the reading of Bruin from the Supreme Court of the United States was that the conduct of having a firearm is presumed to be valid, and the government has to prove that you can't have a firearm.
The post-Bruin cases say there's a rooted in history a limitation that if you are not a law-abiding citizen, that you have limitations on your Second Amendment.
Correct. And those cases that have come out, I don't believe have come from the Sixth Circuit or the districts in the state of Ohio. I know that there's a Fifth District case that does permit people under a domestic violence CPO have a firearm and everything else of that nature. So there are conflicts, and this is ever evolving. And so, at least for the court certification, it is evolving. So as far as Mark's guarantee, he's in a quagmire. So can't buy a gun, and he could be convicted if he has one based upon conduct that he had nothing to do with and a law that was passed after he was punished. And so that's manifest injustice, and that serves the basis of manifest injustice.
What do you mean conduct upon which he had no basis?
Well, so Mark was convicted. Mark was convicted of domestic violence, and I want to make sure I describe it correctly. He was convicted of domestic violence. Then the law is passed after that
The
conviction.
federal law.
Right, correct, but the state of Ohio can still prosecute it, right? The state of Ohio can still prosecute it. And I understand that we're not in the federal court, so passes a law that permits the state of Ohio to prosecute Mark for conduct that has already occurred and that he's already been sentenced for. Because he's already pled no contest, the court has sentenced him, and this, again, in 1991, government passes the law, and now he's placed under a disability. And that's the timeline. And so the state of Ohio says you can't do an ex post facto law. And again, the state of Ohio can't tell the federal government what to do in some instances, but the state of Ohio can guarantee Mark a constitutional right. So how does the state of Ohio guarantee a constitutional right when the federal government says you may not have it? That's the quagmire. And I hope I'm describing that accurately, because that is exactly the quagmire.
You're saying it's a collateral consequence that should rise to the level of a significant collateral consequence that should be informed because it is a constitutional right.
Because it is not only a constitutional right, but it is so there's a substantial right. We all have substantial rights, but the constitutional rights, they're there, and that's what Criminal Rule 11 does. And so the vehicle then becomes is how does Mark attack that, right? So if he files a motion to have his disability relieved, the court can say, no, you've already been convicted of domestic violence, right? We can't relieve your conviction. He goes back to the municipal court and tries to withdraw his plea, and the government says, well, it's too bad, you can't use that as a basis for withdrawing a plea. He's stuck. I mean, this is a classic definition of an ex post facto law because he has no ability to redress his grievance here because he's stuck. And so Mark would submit to the court that the same kind of argument that the transcript says. Mark understands that this court, there has to be a transcript prepared and filed with the court. Mark impressed the court reporter indicated the court, due to the age of the case, there are no audio files available to it, and this court did not hold a hearing in the matter, though it's not required.
Counsel, did you kind of take a look at the record that was sent over to the court?
With the corresponding affidavits?
The entire record. You know, the appellant is required to present the record, and I just wondered if you had taken a look at it.
I have, and the record includes various affidavits from the people that were involved in this incident in 1991. One of the arguments to Mark not being able to withdraw his plea was the issues as far as the witnesses' unavailability. And the affidavits were actually filed by one of the witnesses and the alleged victim and the child, who was not a child, obviously, after this passage of time. So the position for that, for Mark, would be that the witnesses are still available, still remember the event, and the affidavits were presented to the court. So if this court were not to permit Mark
and
to...
And those affidavits were recanting of...
Correct, the events that occurred, yes, Your Honor. And so if this court does not permit Mark to withdraw his plea, at least this court can remand for a sentencing, or excuse me, a hearing on a motion to withdraw the plea. I believe that at the very minimum, Mark has presented enough evidence that a hearing would be required for the trial court to then have a transcript, issue findings of facts and conclusions of law, and then go from there.
Counsel, I was also very confused by what I think I read in the brief about there not being counsel for Mr. Manning, because it looks like they're, from what the record is kind of a mess.
Agreed, absolutely.
That's why I asked if you had taken a look at it. It appears that he had counsel. Tell me why you say he doesn't have counsel.
So my understanding from the record is that the Akron Municipal Court has a front scan file, and that is where the various different sentencing entry was event, where counsel would be listed, the charges and everything else like that. It's a, for lack of a better term, it's the front of the folder. It's the
jacket.
It is the jacket. Thank you. My understanding that Mark can represent the court that his lawyer was not present, and so as far as Mark is concerned.
I'm sorry, where will I find that in the record?
That, I believe, was something that Mark filed on his motion to withdraw his plea in the trial court at the Akron Municipal Court. I believe Mark's, the motion to withdraw was buttressed with an affidavit by Mark saying that he had personal knowledge of all the events that occurred and whatnot and can testify to the same. So to answer the court's question, I would agree that the record is a mess. We've got a jacket and it's a one-page sheet of paper and everything else like that. But
I'm just only proof in the record that there was an attorney is there's a written name on the front of the jacket.
That's the only proof that there was an attorney, yes.
So in practicality, you could come in and say, my attorney is so-and-so, and your attorney not be there. It would be written. So you're saying the only evidence we have that he has an attorney is that it's written on the front jacket?
Correct. Because if there were pleadings or anything else like that, it would have been sent over on the record.
Because this happened when?
1991, Judge. Absolutely. And I certainly understand that. And that's why Mark understands it's a manifest way burden. It's manifest injustice. I apologize. It was confusing too. And it is a high burden. And he understands that given the circumstances, Mark would submit at least at a minimum, he should be permitted to withdraw his plea or there be a hearing held in the manner. Mark appreciates the questions from the panel.
What about the journal entry? You know, typically when you go to the second part of the jacket, that's where a plea would be, and there's a mark where you write with counsel or without counsel. Is there a mark there?
I do not recall them there being a mark, and I don't, and I'll be admittedly blunt, I could not read the cursive handwriting, even though I recognize the person who made the cursive handwriting, I couldn't read it that well, so that could be me misreading it and everything else like that, and the age of the case as well. So I willfully will say that. And if the panel does not have any other questions, Mark will reserve the balance of his 4 minutes for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. I wanted to address your question, Judge Lanzinger. I do not believe that there's any place on that judgment entry in this case where it indicates whether there was or not counsel with a check mark or anything like that. I don't think that the form that they used had a space for that. The form does say Patrick O. Simon was the attorney for Mr. Manning. And Mr. Manning's affidavit does not say, I did not have an attorney present at my hearing. He says, my previous attorney died, and therefore I don't have an attorney, which is just contradicted on its face by what's in the court records. And the other issue I wanted to kind of touch on here is this idea about the transcript. And the argument that I was raising in the brief is not, I recognize the technicality of it, but what is happening here is the record before the trial court was not, the motion that went before the trial court was not, did not address a lot of different issues that it needed to. On appeal, it says, the court order filed something saying, we have no transcript. The trial court didn't know that. And so and that's the argument I'm making is, if you're going to rely on the fact there's no transcript, you need to put that before the trial court at the time, because there's a presumption of regularity in proceedings in all court proceedings. And if you want to challenge, and looking at a transcript from 32 years ago, this is not the same judge. This is not a hearing that happened a year ago. It's not even 6 years ago. It's 32 years. That's as long as Judge Spicer was in the probate court, and he was the longest serving judge in Summit County, I believe. It's a long time, and you need to put that transcript before the judge so the judge can review that, or tell the judge I couldn't do it. Either way, the judge then can take that into advisement when evaluating the affidavit that comes in, which then leads to, but then they come up on appeal and say, well, there's no transcript. You're asking for this court to reverse on a basis that was not available to the trial court when it was evaluating. You're asking to say it abuses discretion because of the fact that it was not presented with. And so that's part of the argument about the transcript. The other thing I want to add in about the affidavits that were mentioned from the wife and the child, those were submitted after the denial of the motion to withdraw. They were submitted as a motion to reconsider the denial of the motion to withdraw. A motion to reconsider is a nullity in and of itself. And again, to say, well, I submitted those affidavits, they weren't before the trial court when it made its decision. And you don't get to basically pepper the record after the fact to try to say the trial court made a mistake when it didn't have all the information.
Did the court rule on the motion for reconsideration?
The court never ruled on the motion for reconsideration, which the case got appealed, I think, before any decision was made. But again, this court's precedent is that it's a nullity.
I just wondered if they made a ruling one way or the other.
I don't believe they did. And the other thing I would say too is that there's 3 assignments of error, but really there's one issue here, is that the trial court abuses discretion denying this motion to withdraw. And again, there's no explanation to the trial court about why you weren't providing a transcript of something that happened 32 years ago. The affidavit that was submitted says, I didn't have an attorney, which is belied by the record, but even if it wasn't, there's no explanation about why that's a manifest injustice 32 years later. You would have known that the day you pled. I didn't have an attorney there. You would, over the subsequent years, you would have learned that. And this idea of, well, I didn't actually commit the crime, well, that you would have known that then too, and had been able to get affidavits from the wife and the child at some point in this intervening period. The delay in and of itself is not a reason to deny it, but it is a factor to consider about whether there's sufficient evidence being put forward to even satisfy it. The lack of the attorney here is not a constitutional violation as it stood at the time. Subsequently, Ohio has said you need to have an attorney there whenever there's a threat of incarceration. At the time, that law was not established, and the existing U.S. Supreme Court case law said you didn't need to have one unless there was actually a sentence imposed that required incarceration, which didn't happen here. But again, it doesn't. This is all going to this overarching idea of what is the manifest injustice here, and it seems to be that I wasn't told that in 5 years the federal government, which is a separate sovereign, was going to do something that would affect my constitutional rights.
Do you think Bruin changes this at all? Because the law is clear about collateral consequences and pleas, and that we don't have to, that the judges don't have to talk about gun rights at a sentencing. Do you think Bruin changes this analysis?
I will concede I'm not familiar with the holding of Bruin. But what I will say is that the collateral consequence, it's an absurd result to say that that somehow your plea becomes not knowing when there's a collateral consequence that becomes clear after the fact, which is not being passed by the state of Ohio, it's being passed by the federal government. And also the state of Ohio doesn't prosecute for violations of 922G. They don't do that. There are some cities in the state that have passed laws that would maybe do that. Columbus has, for example. And that's actually an issue that's being litigated, I believe, in the courts about whether that violates the the gun statute. But the issue here is, was it knowing at the time? It doesn't become less knowing after the fact. That doesn't change the analysis. That's our position. So all of the challenges that are kind of being raised are they try to go back in time, and the case law is clear. Changes to the law don't change what, once your appellate rights have already run, it doesn't change you can't go back and try to raise these things and invalidate the sentence after the fact. And some of the challenge here on appeal now seems to be that the statute, which is RC 2943.033, which is the statute says, we want judges to inform you about the collateral consequence of 922G. However, that's not the basis for withdrawing your plea. The challenge that has been raised in oral argument here is, well, that's not fair. But in the motion to withdraw, in the appellate brief, appellate never even mentions that statute. That's never addressed. There's never been a challenge to that statute being improper. And that statute is pretty clear. You can't complain about the lack of knowledge about 922G, even if it was required to be given. The fact that you want to say, when it wasn't even required, I can use that as a basis to undo my plea, that the second district said you can't be a retroactive application of that. And so the reality ends up being here that even taking everything that's kind of being said in the affidavits as true, it doesn't create a manifest injustice, because it's never explained how, after 32 years, and by the way, this law has been in place for 26 of those 32 years, how is this a manifest injustice that requires withdrawing the plea? The idea that we have all the witnesses, but I do not know who the investigating officer was. I don't know who 32 years is a long time to expect us to be able to find the original law enforcement officers that were involved here. There's a reason statute of limitations exists for these. It's because evidence goes stale. The idea that we're going to be able to reopen anything 32 years later because is just like, there's no way to do it in a way that doesn't create undue prejudice to the state. Which is why I don't think that even taking everything that's in the affidavits as true, even though they're contradicted by the record, even though they're contradicted by, like, just logic, I don't think that they would form a sufficient basis to say there could be a manifest injustice that would even require there to be a hearing here. And so the court denying it without a hearing was completely within its gatekeeping function, which the Supreme Court recognized when it was saying that we're allowing, we're not going to follow special prosecutors anymore. With that in mind, I don't have anything further to address here. That's just a question from the panel. We would simply ask you to conclude that the trial court did not abuse its discretion here, based on the record before it and based on the evidence that was the arguments that were advanced.
Thank you.
Thank you.
Thank you, Your Honors. May it please the court. As far as rebuttal is concerned, Mark will note that the Lautenberg Amendment is this code section on page 10 of Mark's brief that was referenced as well. As far as this is concerned, again, Mark has laid out his arguments. I mean, it's in a procedural quagmire.
What's your response to the no explanation of why there isn't a transcript at the trial level?
So Mark understands that you're trying to give the trial court the best opportunity to make the decision prior to making an appeal and everything else like that, and that's what the genesis of a motion to reconsider is. Sure, the court may consider it as a nullity, but you also want to make sure that it's in the record. And as far as getting a transcript or everything else like that, Mark's understanding as far as a motion to withdraw the plea is that if the court would set a hearing, that would give Mark the opportunity to press appeal that transcript, much like an appeal would, and then no transcript would be available. Does that answer the court's question?
Yes, I guess do you agree that it's fatal for you not to tell the trial court the reason you don't have a transcript and not provide a transcript? Not provide a transcript without telling them the reason there isn't a transcript?
I don't think it's fatal to the cause on a motion to withdraw. I mean, on an appeal, if there is a transcript that exists, in this case, we don't have a transcript that exists. So to borrow the phrase from the court, if there was interference, it would be harmless, because even if Mark were to give the transcripts to the trial court, what transcripts are there? They don't exist. So the trial court, even if they had the transcript, even if they existed, couldn't have made the decision. So the trial court wasn't missing any information because this information did not exist. And so as far as Mark is concerned, again, he would indicate to the court that at a minimum, this court should reverse the trial court's finding that no hearing was had and order the trial court to have a hearing in this matter. And we appreciate the court's time if there's no other questions from the panel.
Seeing none, thank you both today for your presentations. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, the clerk will mail a copy of that to you. Opinions are also posted on the High Supreme Court website. With that, the court is now adjourned until